Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, for those that are not aware yet, apparently Sarah's little ad, her little graphic design poster, actually worked, and an attorney has decided to sign on and help her out. So we're going to go through. He made his first motion, and it's a motion to continue. So I'm going to pull up the Orange County court records here. So this was actually filed on the 30th. And I'm posting this on September 1st. So yeah, there's been a lot going on between Madeline Soto's case and now Sarah Boone's case. So I'm doing my best to try to balance a little bit here. But I had heard about it, I just hadn't gotten to it yet. So I'm only a couple days behind, so it's not too crazy. So here's the filing from the 30th. I believe there's a court hearing coming up after the holiday tomorrow. So I'm going to double check on that as well. All right, so this is a defense motion for continuance. State of Florida versus Sarah Boone. Defense motion for continuance. Comes now the defendant by and through the undersigned attorney under Rule 3.190 of the Florida Rules of Criminal Procedure and requests this court to grant a continuance of the 3-week jury trial set to begin on October 7th, 2024, and alleges 1. The defendant is set for trial by jury on October 7th, 2024. 2. The defendant has just retained defense counsel, and a notice of appearance was filed on Friday, August 30th. So Friday, all this stuff started to come out. So I think she's seen this attorney a few times, and we will get into that. It does show how many times this attorney has come and seen her at the jail. 3. 38 days remain before trial. 4. Defense counsel has met with the defendant, here we go, 4 times at the Orange County Jail, August 20th, August 21st, August 26th, and August 27th. 5. During these meetings, the defendant has disclosed potential exculpatory evidence on her phone in the possession of the Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. This evidence will potentially corroborate her anticipated battered spouse syndrome defense under Rule 3.201 of the Florida Rules of Criminal Procedure. I don't know why I stumbled so much reading that one. I think it's just been a long weekend. Number 6. Undersigned counsel has spoken with numerous potential expert witnesses covering a range of possible defenses. Counsel is also actively vetting several additional experts upon directives from interested parties. 7. It is the professional opinion of counsel that the retention of one or more of these experts and the development of the aforementioned defenses is a crucial and necessary component of the defendant receiving full and competent representation and due process under the law. 8. Based upon the conversations that have occurred, counsel has learned that proper diagnosis and development of said defenses requires time, not only for administering appropriate testing, but also the necessity that any expert testifying on behalf of the defendant has to be given adequate time to establish a trusting relationship and then be allowed to apply the analytical tools to the information developed from interviews with the defendant and supplemented with historical and documentary information from third parties. 9. This process, as described to the undersigned counsel by renowned and respected experts, cannot be accomplished in the time available before trial, particularly given the JAC ministerial hurdles which must be cleared when dealing with an indigent defendant. 10. Notice of intent to rely on the battered spouse syndrome defense must be filed 30 days before trial. The notice must be filed by September 7th. 8 days away. 11. The defendant has been deemed indigent for costs. The defense will need government funds to assist in paying the experts in this field. I'm going to discuss all this, so I'm trying to just read it first here. Number 12. Defense motions will need to be filed concerning the potential Brady material. 13. The defendant has the right to be represented by counsel of her choice. The defendant attempted to solicit private counsel after the court's order dated June 28, 2024. The defense counsel responded to her advertisement and was retained. Good win for her. 14. The defendant is not trying to delay the proceedings or abuse the process by retaining counsel at this late date. 15. The defense certifies this motion is made in good faith. And then it goes through the memorandum of law. The Sixth Amendment of the U.S. Constitution guarantees that any person brought to criminal prosecution in a federal court must be afforded the right to assistance of counsel for his defense. And it goes into all that. Let's see. The matter of continuance is traditionally within the sound direction of the trial judge, and it is not every denial of request for more time that violates due process, even if the party fails to offer evidence or is compelled to defend without counsel. Contrawise, a myopic insistence upon expeditiousness in the justifiable request for delay can render the right to defend with counsel an empty formality. The right to the assistance of counsel not only reaches the trial stage, but it extends to sentencing as well. Further, the Supreme Court has stated that implicit in this right to counsel in the notion of adequate time for counsel to prepare the defense. Let's see. The prompt deposition of the criminal cases is to be commended and encouraged, but in reaching that result, a defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. Again, all those cases are cited up there, and I'll put the link again to the website if you guys want to go back and read all that. Wherefore, the defense would respectfully request the court consider this request and grant defense motion to continue. And it's signed by her new attorney, James Owens. He's out of Milton, Florida. Okay. Now, as much as we don't like the fact that she's doing this, first of all, I don't know if he knows what he's getting himself into. But Godspeed to him. I think the judge will probably grant this. And honestly, this should be her last continuance if that happens. Because she's a fool to go pro se and do all that. And this man, he's not going to get a penny to do this. I'm going to assume he's doing it because he hopes he'll gain some money from the publicity, what have you. Because the only thing that he's going to get is potentially money for, from JAC for expert witnesses and stuff. So, personally, this attorney, he's going to work for free. Let's be honest, he's going to work for free. So, I think Judge Kranick will probably grant it. I think if he does, this should be the final and period to grant a continuance. I don't know if that means he'll give them another month or two. He'll give them to November, December. I can't, I'm not the judge, I'm not an expert, but I do think that personally, as much as I want to see this get going, and I know most of you do as well, I think that he should grant her one final continuance, being that she has gotten this free attorney, I'm gonna call him this free attorney, and he wants to work for her and represent her, and I think she's lucky that he came forward, and she saw how screwed she was Let's be honest. She saw how screwed she was. Because you're a fool to represent yourself. We all know that. So I do think he'll probably grant it. And as far as, like I said, monetary wise, it's only going to be, they can apply for the JAC right here for experts. Because he knows he's not getting paid. We still haven't dealt with, now we still haven't dealt with the money from her other attorneys. But that's a separate matter, even though it's all under her. And does look like there's some a pending hearing coming up for that. So I think he's going to grant it. I don't know when the next court hearing. Now they had September 3rd listed. Remember they were going to do September 3rd, and it's not really on here. Actually, it is right here. I don't know if you guys can see that. So I'm thinking that's Tuesday, okay? Because tomorrow is Labor Day. I'm thinking that this is when they're going to hear this filing for the continuance. Again, I think he should grant it, and this will be it. The final shoe is going to drop, and either she's going to sink or swim with this new attorney. And looks like there's also, I think the 924 hearing up here. I believe that this is Lisa Munyon. I'm guessing this has to do with the previous Cashman and them, what they're trying to get their payments. Again, I'll look further into that. But if somebody knows, please let me know in the comments. But I'm thinking that that's what that hearing for is right there. Because the 26th, which is 2 days later, is the trial management conference. Currently, that's what we have sitting on her docket. And then we also have here a notice of appearance. And here's his actual notice of appearance. So here's him telling the court, I am attorney James Owens, and I am filing to represent Sarah Boone. Again, I think she got lucky in all this. And I wish him the best. So this one here, notice of provision of discovery. Here is the last filing that's on here right now. Comes now the state of Florida by and through the undersigned assistant state attorney and gives notice that the below listed exhibits have been disclosed to James Owens as follows. All right, so her new attorney has seen all these exhibits, or electronically it looks like anyway. The filing had been sent electronically on August 30th. Discovery pages 1 through 421. Witness lists and records. Following digital evidence is available for copy. 1 CD with 911 call. 2 DVD with interviews. 3 DVD with videos from Sarah Boone's cell phone. 4 DVD with public surveillance video. 5 DVD with photos. 6 DVD with suitcase video and device photos. 7 DVD with ME photos. 8 DVD with audio interview, Brian Boone, Sarah Boone interviews, cell phone videos. Oh, I would love to see Brian Boone's interviews. Number 9, 8 gigabyte USB 3D scan. And it looks like that's from our state attorney, assistant state attorney, David Cacciatore. So they've given him that stuff. It looks like they're just trying to get the media for him to do that. So looks like we are progressing in a different way than I expected with Sarah Boone. So, what do you guys think? Do you think that Mr. Owens has any idea what he's getting himself into? I hope he knows. He's researched the case enough to know how difficult she is, as much as most of us do. Again, I don't fault her getting an attorney. I don't at all. Because remember, you're a fool to not have an attorney, especially in a case, you're being charged with murder. But I mean, I do hope that this works out the best for her. The thing is, she thinks she's going to get off, and we all know that it's not going to necessarily go the way she wants. But at the same time, I think it scared her enough to see all that, but maybe it didn't scare her enough. But I think she's lucky that this guy stepped up, and I have looked up a bit about him. I'm going to see what else I can find out. But he looks like he's a family man. He's married. He's got I think 2 or 3 kids from what I saw. So again, I think he's going to do it to for the publicity. I'm sure he's hoping he'll get a book or some kind of special on it. Who knows? But he knows at the end he's not getting paid by the state, but it may help him out in his career and otherwise. But let me know what you guys think about the fact that her ad worked. She got an attorney. That nice ad that she hand wrote and took care of herself in her cell. Well, guess it worked wonders for Sarah Boone. All right, guys. I hope you have a great rest of the day, and most of all, stay safe.